Hi, good afternoon. I've got that it's right at 2 o'clock and we are going to go ahead and get going. Welcome and thank you for joining us today for the November session of our Community Associations Building Blocks webinar series. Today's session will cover the topic of Directors and Officers Insurance. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be your moderator this afternoon. If you have any issues today with video or sound quality during the presentation, please reach out to me via the Zoom chat feature and I'll try to troubleshoot with you. Additionally, our speakers are happy to answer questions throughout their presentation. If you have a question at any time during the presentation, please type it in the Q&A box. Today's speakers are Alan Trask and Amy Wooten. Alan is co-leader of our Community Associations practice group and works with North Carolina real estate developers and the community associations that they create to handle a wide range of issues, including the preparation, amendment, interpretation, and enforcement of restricted covenants and governing corporate documents, deferent control, transition and disputes, fiduciary concerns, and collections. Amy is a litigation attorney whose practice focuses on complex commercial disputes, fiduciary duty claims, unfair and deceptive trade practices claims, and community association matters. In addition, Amy has significant experience representing policyholders in a broad range of first and third-party coverage litigations with their insurance carriers. Alan and Amy, I'll turn the mic over to you and we can begin.
Hello, everyone, and welcome. Certainly appreciate you being here to talk about this so important topic that we run into all the time in the community association space. And it's interesting, Amy and I have both been practicing just a little over a decade, and this area has developed quite a bit in our run of things. When I first started, the sophistication of directors and officers liability coverage was not terribly high and really didn't apply to the HOA space, the condominium association space. We've seen that change dramatically in North Carolina over this time. And so it is a very important topic to be up to speed on. And it is something that is worth revisiting almost every year, especially with your new board members. So today we're going to talk about all kinds of things that touch on the directors and officers liability coverage world, but wanted to go over some basics to get us started. So first of all, what is it? Who can it cover? What does it protect against? What are we talking about? You can get insurance to adjust the risk for all different kinds of things. It's common for folks in the HOA space to have general liability coverage. So to cover against injuries or harm to folks that happen on the land or in the facilities, if someone slips and falls at the pool, something like that. Directors and officers coverage is a little bit more specialized. And what it does is, in a nutshell, it protects the board's decisions and actions that are taken sort of on behalf of the company. So as a board of directors, I mean, you are the body that the company, the association acts through. And in making those decisions, they're going to have impact and they're going to have potentially disparate impact on folks. And they can give rise to claims, but there are layers of protection, not only in the law. Some of the legal protections are beyond the scope of this presentation, but there's immunity and indemnification under the law, but also there's the opportunity to adjust the risk through the purchase of directors and officers liability coverage, which is a good and a necessary thing this day and age. Who does it cover? It covers, generally speaking, the board of directors, but it also can cover all kinds of other folks. And we're going to talk in a little bit more depth about this: agents, employees, spouses, volunteers that are beyond the board of directors. Think about a standing committee like an architectural review committee or a covenants and enforcements committee, something along those lines. So it can reach out and cover those folks as well. Generally speaking, with some exception, we are talking about lawsuits being brought sort of within the association. So member lawsuits against the association, derivative lawsuits, that sort of thing, the disputes with developers from time to time, all of those types of things are what can fall under the ambit of D&O coverage.
All right, so one of the things that you tend to think about when you're looking at community associations insurance, is this something I'm required to get, or is it something that I can get? For example, we know that the Condominium Act and the Planned Community Act in North Carolina both require community associations to get certain types of insurance. One of those examples is property casualty insurance, and they have certain provisions that detail how that process works, what the values are that you have to look at in obtaining that insurance. But what about directors and officers insurance? Do the statutes require that, or do they simply allow an association to get that? Well, the starting place on that analysis is in Chapter 55A of our general statutes, which governs it's the Nonprofit Corporation Act. And community associations are nonprofit corporations in North Carolina. They do fall under that statute, and that statute does set out a permissive standard for insurance. So it allows nonprofits to get directors and officers insurance that would provide for indemnification. It generally would allow for you to get that insurance. There are a couple of exceptions on what you cannot agree to indemnify someone for. That's very limited and generally would arise in the context where you're trying to indemnify someone for conflicts of interest. But on the whole, you are able to procure insurance for directors and officers just by virtue of being a nonprofit corporation. The Planned Community Act and the Condominium Act also both speak to whether or not you can provide insurance in this space for those particular types of organizations and associations. Both of them mirror Chapter 55A and setting a permissive standard for that insurance. And they both allow, unless the organization's declaration or articles of association expressly provide to the contrary, to get directors and officers insurance. Alan spoke a few minutes ago and alluded to the fact as to why associations need this kind of insurance. And the reality is that while community associations are operated through boards of governors or boards of directors, however that particular association identifies its executive board, and those entities or governing bodies that are formed by volunteers, it doesn't change the fact that these associations are in fact corporate bodies recognized by the law as such, and that they're exercising their judgment through boards of directors who are going to be at times questioned on the decisions they make and will face claims or litigation arising out of those decisions because of the impact that they have. So it's very important to have that insurance available for your boards. It's also important because you are going to have a harder time attracting quality volunteers if they're aware that that protection is not available to serve on the board. So just an added consideration for the value of that insurance there. On the issue of coverage types, directors and officers insurance has two basic buckets of coverage.
Hey, Amy.
Yes.
This is Jen. I'm sorry to interrupt you mid-presentation. We're having some comments that it's very hard to hear you. I'm not sure what's going on with your mic. Do you want to take just a moment and dial in by phone for your audio? And Alan, maybe you can pick up for just a second while Amy corrects that. Great, thank you.
No problem. So when we're talking about coverage types, this is a really critical distinction for us to make. There are really two things that you get in lots of different insurance policies, but especially in directors and officers coverage. There's the duty to defend. That is something that you're purchasing. And then there's the duty to indemnify. So what are the differences between those two things? We often think about who has to pay what at the end, as if the process getting to the end doesn't matter. And in reality, the process getting to the end is the most important part. Why do I say that? 95% of cases settle. It might be more than that. So, and lawyers are really expensive, unfortunately. So a lawsuit is not a situation where someone who is suing someone else just throws out some allegations and then all of a sudden they have a result and they take it to the bank. A lawsuit is a long, drawn out process where everyone gets to argue their case and ultimately have that case decided by a judge or jury. But it takes time. It takes a lot of work. Everyone is afforded that opportunity to have their day in court, which comes with a cost. And that's where the duty to defend is so important. So whether or not this particular plaintiff that you may be dealing with is right or wrong, you're going to have to defend that claim. If they bring it, if they sue, you're going to have to find a way to defend that claim. You can either do it out of pocket, or you can trigger your D&O coverage to step in for you and provide a lawyer. So the duty to defend is really providing you with a defense, paying for your lawyer. So that's one duty. The duty to indemnify is what we often get hung up on. That is actually paying for a judgment that is entered against you. So you go to court, you lose. The plaintiff gets a money judgment. The appeals are done. It's time to pay up. That's when the duty to indemnify kicks in. And what we're gonna talk in a little while about how you deal with what the carrier's response is on these two things. But that's a little bit about the difference between the duty to defend and the duty to indemnify. And it's really important to understand that distinction because they come with different coverage limits, but also impact one another. You're still on mute there, Amy.
Sorry, didn't realize I did take it off mute when I was on the phone as well. One thing just to add on to that point on the duty to defend and indemnify, there are situations where a policy may not provide coverage for certain things like fraud, for example, or allegations of criminal conduct or ill-gotten gain, and the policy will expressly exclude those items from the duty to indemnify, but that doesn't necessarily mean that the result there is going to be that you have to pay to defend those claims. Most of those policies are written in such a way that the carrier is still obligated to defend those types of allegations, and the issue of indemnification won't be decided until after there is a judgment or down the road in the case. So just something to think about there. Those are two completely distinct duties. There can be some overlap in the way you may need to think about them, but they do operate independent of one another, as Alan said.
Annie, this is Jen. I'm really sorry. We're still having a really hard time hearing you.
Okay, I don't know how to fix it. My volume's at 100% and I did switch over phone to audio. I'll try picking up the handset and see if that makes any difference.
Alan, do you mind just pick it up and we'll keep going
if
and
you're
I'm
on
gonna
to the
help
next
Amy
slide.
offline.
Okay, so we've talked a little bit about, what is directors and officers coverage? What are the reasons that you would want to get it? I want to talk a little bit about shopping for it. We've seen the products change in a meaningful way over the years. And remember this too, when you are dealing with any kind of insurance, whether it's personal or business, the carriers will insure just about anything as long as you'll pay for it. And so if you talk to them about what you want, they may charge you more for it, but a lot of times they will add things to your coverage. You just need to know what is covered and what is not. And that's what we want to talk about a little bit about here so that you can really engage with your insurance agents and make sure those policies are what you want them to be and what you want to buy. Remember, you think about pulling a box off a shelf when you're buying insurance. And the reality is the carriers are all too willing to customize coverage to you and your needs. That goes for home insurance, auto, all different kinds of things. You just need to have a dialogue with the agent and with the carrier about what it is that you want. We're going to give you some questions to ask here. Look, there are any number of considerations to put into play when you're adapting coverage to your community and your specific needs. We're going to go through a few of them. We've written some articles on this. One that is one of my favorites, our partner Adam Bowden wrote about, and it is entitled, and I love this, "Making Sure the Good Deed Goes Unpunished." And so you can look that up. We'll circulate the links for that. That's out there in the internet space. Key questions. Who does it cover? So certain policies can start with covering the board, but you can add all different kinds of coverage to it. So the things we talked about earlier, spouses of board members who surprisingly find their way into these lawsuits frequently. Why do they find their way into these lawsuits? Because their spouse member, who's on the board comes home, tells them something, they can then go and tell other people about it, and all of a sudden you've got a problem. Whether the policy covers non-monetary loss. What do we mean by that? So if your decision as a board causes someone to lose property value and they're suing for an amount of money. They're saying you owe me X dollars because your decision negatively impacted me. Well, that is a monetary loss. So they're looking for money in that lawsuit. But more and more often we are seeing, and frankly, we have brought some cases for non-monetary relief. And what is that? Well, that is, we disagree about what the covenant means, what it says, what authority it gives to the board. One that is sort of a hot topic right now are these covenants that are out there that purport to give a board of directors the ability to adopt a rule and regulation that restricts short-term rentals. That is akin to a covenant that tells the board that the board can tell the members that you can and cannot sell your property. And so those are controversial things, and those are things that are ripe for lawsuits, and you want your coverage to kick in for non-monetary relief claims. Does the policy cover wrongful termination or HR issues, things like that? Does it cover unlawful discrimination claims? Again, these are all things that you want to decide how comprehensive you want the policy to be. And you want to be really thoughtful about what you pursue. I'll give you a quick example on that. If you want more folks to be covered by the policy, for instance, you want all the volunteers, all the employees, all the managers, all the agents to be covered by the policy, then you want to think about your coverage limits. And the reason is, if the plaintiff sues all of the board members, all of the members of a committee, and the management company, and I've seen plenty of those lawsuits, very likely you're going to have at a minimum 3 lawyers involved in that. And all those lawyers are going to be charging their fees against the duty to defend amount. So whatever that is, let's call it $1 million. Maybe $1 million is plenty for that. Maybe it's not. And an additional $1 million on top of that is probably not going to be a significant increase in premiums. So that's just one way of thinking about, in a sophisticated way, about how you adapt these policies. I would consult with your attorneys, be that us or other attorneys. They can help you with that. And that's a good source of feedback. Even if you need to pay for it, it's worth it, because you need that perspective to marry up with the insurance agent's perspective and your own. So those are just some things to think about, and we can certainly continue to think about those things, look at our stuff online. And if you've got questions, call us. We're always happy to talk about that, but definitely get your insurance agent involved in that. So I want to talk a little bit about endorsed policies versus standalone policies. When Amy and I, Jen, do you mind going back one slide? So when Amy and I first started out in the business, most of what we saw were endorsed policies. And what does that mean? Well, an endorsed policy, or excuse me, an endorsement to a policy just is a tag along document that changes the underlying coverage. So say you buy a policy for $1 million and it covers just you, and it covers just monetary claims. Well, you can buy, let's call it, buy an endorsement that you would tag along to that says, okay, now this also covers non-monetary loss or claims. And so it's just something that changes it. You want to do a quick sound check?
All right. Can you guys hear me now?
Yes.
I feel like a Verizon Wireless ad. Can you hear
There
me
you
now?
go. There you go. No, that's much better. I'll let the rest of the group chime in on that, but it's much better on my end. So what we saw for a long time was a general liability policy would have an endorsement for directors and officers coverage. And it would be one page. It would be very straightforward. And it would be, frankly, lackluster. And those were prevalent. Later, about 3 or 4 years into our careers, we started to see standalone policies pop up. What are standalone policies? That is where you have an entirely separate policy just devoted to directors and officers coverage. And frankly, those have become the norm these days. And those are often with different carriers than what your underlying coverage would be with. And so there are meaningful differences between those two. Now, most of what you're going to run into these days are standalone policies, but we need to talk about the differences between the two. Coverage depth, coverage limits, premiums, all of that sort of thing. So when you have coverage with one carrier, let's call it just carrier A, and carrier A has sold you 3 different policies. If you make a claim on policy 3, it is very likely to affect your premiums on policy 1. And if you're all with the same carrier. So that's something to really consider. Also, we saw a lot of blending of coverage limits where, for instance, associations would buy a general liability policy, they would get $1 million of coverage. They would have an endorsement for directors and officers coverage, but it was under the same coverage limit. So really what that association had done is bought $1 million of coverage for everything. Well, the trouble with that is that in some cases, you want to have as many insurance carriers at the table as possible with as high a coverage limits as possible to protect you. So think about it this way. If you have separate policies, $1 million each, someone brings a lawsuit, triggers all the coverage, you've got $2 million available to you in theory. If they're all under the same hat, then maybe you only have $1 million. And I know we're talking about $1 million like it's a bunch of money, and Lord knows it is. But in some of these lawsuits, it can get eaten up really quickly, and we want you to be aware of some of the benefits of a standalone policy versus an endorsed policy. With respect to premiums, how the claims history works, coverage limits, all of that sort of thing. It's much cleaner and easier and a little bit more expensive to just have a standalone policy. Also, as a last comment on that, the standalone policy companies, and no, I do not work for any of these companies. I'm just giving you some examples. Our firm generally does not work for insurance companies. We represent the associations directly, but I just want you to have some idea of what some of the carriers are that provide standalone policies. Travelers, CNA, Cincinnati, those are all names in the business that you hear all the time that routinely provide these standalone policies. And so I would certainly encourage you to explore those versus endorsed policies. If you're going to go the endorsed policy route to save money or what have you, just make sure your insurance agent knows that they need to beef that up as much as possible. And certainly your attorneys can help you decide that. Jen, you can go on to the next slide. So, all right, we've talked about what D&O coverage is, whether you should get it, how to buy it, all of those sorts of things. Well, we want to talk to you a little bit about how to use it, how to put it in play when you need it. And I hope you never do, But if you're faced with it, it's just a part of association governance, and we want you to know how to kick it into gear so that you can take advantage of what you're paying for. Some things that we're going to talk about are requirements for triggering coverage. You want to make sure that you are doing what the policy tells you to do in order to get that coverage in play. Remember that an insurance policy is just a contract. The carrier has obligations to you, which you have bought and paid for, and you have obligations to the carrier. Things like letting them know at a certain time that something's in play. We'll talk about all of that. We want to talk about typical responses from the carrier and how to navigate those and how to make sure that you, as the association, are protecting yourselves, protecting your rights, making sure you're getting the maximum value out of that policy. And then we want to talk a little bit about managing the process from the selection of defense counsel kind of on through the rest of the case if you're faced with the case. And just to be clear, we're talking about litigation cases. This is something that actually gets this off the ground. No policy is really going to kick in without a litigation case in place. And so that's sort of the umbrella under which we're talking about these things.
Most of these directors and officers policies, and Alan was speaking a minute ago to the importance of, making sure you're following the process, making sure that the claim that you have falls within the ambit of the policy. And most of these are going to be claims, what we call as claims first made and reported policies, as opposed to an occurrence-based policy, which you tend to see in a general liability insurance policy. So what's a claims first made and reported policy, and why does that matter? What's so important about that? And knowing that on the front end when you're dealing with breach of fiduciary duty directors and officers type claim. Well, the real reason it's important is because if the claim is not made first against the insured, the association's directors and officers, whoever falls within that definition of insured under the policy, if that claim is not made during the policy period for the first time and it's not reported to the insurance company during that same policy period, then the policy doesn't apply. It won't kick in to cover that claim. So an example of that would be, let's say you've got a policy period of July 1, 2021 that runs through July 1, 2022. And the claim is made on July or June 30, 2021. And you don't report it until August of 2022. Well, that claim is not going to qualify as a claim first made and reported under the 2021-2022 policy. And you're going to get a denial from the carrier if they're paying attention to the policy language when they receive that claim. So it's really important to look at when did the claim get made and is it within the policy period. If those two conditions are met, then you do want to make sure you go ahead and get that in and over to the carrier as quickly as possible at that point. I do want to point out just one language you see on the slide, an example notice. These policies do tend to state either in bold text or in some sort of manner that calls your attention to it that it is a claims first made and reported policy. This particular one also points out that the limit of liability that's available under the policy is going to be reduced or it may be completely consumed by the payment of defense expenses. And what that means is that the policy has limits that are essentially eaten away by the costs incurred by the carrier to defend your claim. That's extremely important to be cognizant of because while your declarations page may show $1 million in coverage, and most of us would think, well, that means that if there's $1 million judgment, there's $1 million available under the policy to pay that judgment. And that's not actually what it means when you think about the fact that the policy will reduce that limit by the amount of money they spend defending it. Whatever money gets paid to the attorney to defend the claim, whatever money is spent incurring expert witnesses and covering their fees, court costs, filing fees. All of those things will come out of that available limit. That may not end up being particularly important in some cases, but there are many circumstances where it will be very important. As Alan mentioned, litigation can take a very long time. It's inherently expensive. And a lot of these policies, you have to look at what is the scope of who they cover. You could have, for example, a master association who is the named insured on the policy, and in communities that have sub-associations that are also insureds, additional insureds, whatever the case may be under that policy, most of the time, the way these policies are written, that $1 million limit of liability is going to apply to the same occurrence, whether the master is involved, its board of directors is involved, and the sub associations and theirs are involved. Where you can see this come up in particular, or where Alan and I have seen it come up more recently, are in cases where unit owners or members of the community are not pleased with the way the master association or sub association has handled property casualty claims with their insurer, and it can snowball into some very complex litigation very quickly that triggers breach of fiduciary duty claims or includes those claims, and therefore triggers directors and officers liability insurance. But for policies with lower limits, when you've got 3 or 4 different insureds involved that need to be defended, and unfortunately, it's not uncommon in those instances for those entities to have conflicts of interest between each other, and therefore the likelihood of having one law firm be able to take on the role of defending all of them is very small. So, if it exists at all. So, what you end up seeing is the need to get multiple law firms involved to defend those cases, which means you're quickly eroding those limits because you're essentially multiplying those defense costs by however many number of law firms need to get involved to cover those defenses. So, just wanted to point that out. It is something to make sure you're aware of. Is your policy an eroding limits policy? And how many insureds are we going to have on this policy? Do we have enough coverage to cover a potentially worst case scenario where all of the insureds end up in litigation under the policy? Jen, if you can move us on to the next slide, that'd be great.
Well, I would just kind of as a rule of thumb, to do the best we can to simplify this and give you, I don't know, a rule of thumb is the more people that are covered by the policy, the more coverage limits you need. I don't think that, if you have the board, the spouses, the volunteers, and the management company all covered, $1 million is not enough. You need 5. And so the difference in premium cost between 1 million and 5 million is not significant. It's not significant in the scope of things. Now, if you're going to reduce the amount of folks that are covered by the policy, maybe you can tap dance around that a little bit. And I saw a question come in that goes, what if you're undercovered? Well, that's not good is the answer. Because, the real world application of what Amy's talking about is when that amount is eroded down to 0, the carrier is going to wash their hands and step out of it. And all of a sudden, not only is everybody who's a participant in the case as a defendant responsible for paying their lawyers from then on out, but also you don't have any shot of the carrier paying any judgment if you lose. And so we're talking about a situation that you can't fix after the fact. Once the claim is made, you cannot up your coverage. So you need to go and deal with this now versus waiting for it to whip around. And I'll make the point for the 3rd time. The amount of money we're talking about, it's not $100,000 a year difference in premium to go from 1 million to $5 million. I mean, you're talking about a far, far, far less amount than that. So I got another question. Are your personal assets at risk? So if you are a board member so speaking specifically to board members, then you are technically responsible for your own actions. And so, yes, there is a universe, and it's one that's very difficult to travel to, I will tell you, but there is a universe where your personal assets may be at risk. Now, typically, we only see that come up in sort of intentional torts, intentional discrimination, those sorts of things. Somebody like targeted someone or something along those lines, egregious conduct. But there are legal protections that we mentioned earlier. There's legal indemnification and legal immunity that applies as long as you're acting in good faith. So that's sort of barrier number one, and that's beyond the scope of today's presentation. But barrier number two is that directors and officers coverage. And what we are telling you is don't rely on the law. Go ahead and get the coverage. Not only does it protect the association, but it protects the board members, and it liberates everyone to think and act more freely in running the company. But yes, everyone should know that when you take that chair, you are responsible for your actions at the end of the day. And there is a universe, however difficult it may be to travel to, where your personal assets may be at risk. And when you're buying this type of coverage, you should not be looking out for yourselves. You should be looking out for the company. But look, the benefit to you as individual board members is a good, healthy collateral benefit of getting that coverage for the association.
All right. So what do you do if you've got a demand that's come in, a written demand for monetary relief is brought against the association, its officers and directors, or you get a lawsuit? What should you do? Well, the first thing you should do is should go and find your directors and officers policy and begin the process of giving notice of the claim. A lot of times your broker can help you with that if you've got a particular agent that you work with, but it is important that you promptly do that. Part of that goes back to what we talked about earlier about the fact that these are typically claims first made and reported policies. So it's very important that when you do get a claim, you're giving notice of that in the time frame that's needed for it to fall under your particular policy. You also don't want to delay in doing that because you don't want to miss an opportunity for the carrier to get involved out of the gate and have defense counsel assigned and incurring costs. One of the things that is an unfortunate reality of working with insurance carriers is nothing happens fast on their end. So you typically are only going to, you're only going to have 30 days to respond to a lawsuit that is filed in state court. Once you are served, you can get an extension of time, all of that. But out of the gate, you've got 30 days to respond. So you need to get that notice into the carrier. It will take them time to evaluate, get that claim in the right bucket at the company, and move forward with assigning defense counsel. So if you wait until day 20 to do that, you put yourself in a situation where you're going to be potentially scrambling to move forward and get something on file with the court or an extension entered that's handled by and the costs incurred by a defense attorney that's assigned by the carrier. So just make sure to do that as a first and preliminary step. Claim mechanics. So insurance companies are very formulaic. They are check the box kind of organization, and they operate on technicalities where they can. So it is very important when you are submitting a claim to follow the specific procedure that is set out in your policy. The policy should have a section that clearly delineates how and to whom notice of the claim is to be given. An example of that can be found on the slide. This is a claim notice section of a policy that gives you 3 different methods by which you can give notice of a claim under this particular policy. They typically will set out the exact information that you should submit. In the event that it's a lawsuit that you're submitting, you would send a copy of the complaint and summons if you've received that on to the carrier. If it's a demand letter where the claimant has said, we have a claim for breach of fiduciary duty, we've been damaged in whatever amount, something along those lines, you would then submit that to the carrier as well. I would also caution you to err on the side of sending demand type documents or letters that give a reason to believe that a lawsuit is coming. While it may not technically fit the definition of claim under the policy, some carriers tend to be a little bit more cautious and may be willing to be involved earlier in the process so that they can help monitor and control that situation as it develops. So, just another thing to think about there. And obviously, if you have any questions at all about how to give notice of a claim under your policy, you've got a number of resources available to you. You can talk to your corporate counsel who works with the association. You can reach out to the broker if you have a broker that you typically work with on these things to ask questions about claim mechanics. And there are also generally a number of phone numbers that are listed in your policy where you can call and request information on that too. So don't let confusion on the process impair or be an impediment to getting that ball started.
So here's speaking a little bit to Amy's slide there. So there is a whole process for getting the carrier involved, and you start that process by tendering the claim, and then they will respond, and they respond in a host of different ways. Really, you can boil it down to three, even though there's some variation of the three. The first is just an acceptance of the claim. They acknowledge that there is coverage. They acknowledge that they have a duty to defend. They say yes to indemnity, yes to the duty to defend, and you are up and running. That never happens. What we normally see is one of the other two options. So the first is just a straight up denial. They will send you a letter, and it says, the carriers will send you a letter, and it says, you gave us this demand, we've analyzed it against what the policy covers. They'll look through, cite exclusions in the policy. For instance, if there's a lawsuit for an intentional tort, something where a board member is defrauding someone that is in the community or something like that, that's something that's going to be excluded as just a matter of course. And the carrier, when I say they, I mean the carrier, will cite to all of that, and they'll wrap it up in a bow in the end saying, good luck and God bless, we're out. The third option, and this is probably the one that we see more often than not, is a reservation of rights. And what they'll say there is, okay, look, we're not going to make a determination at this time as to whether we are on the hook or not. But what we will do in the meantime, we're going to reserve our rights to do that. But in the meantime, we'll provide you with a lawyer. And then that way they kind of hedge. And we're going to get into why they hedge and how they use that. But that is most often what you're going to see. No matter what response you get from the carrier, you need to give it to your attorney and get their opinion of it. Because this is not something that, as you might imagine, and like we talked about, the stakes are high here and time matters. And you do not want to just roll over and accept what the carrier has told you. They may be wrong, or they may be reading the policy under Pennsylvania law or sort of standards of practice rather than North Carolina. You're dealing with national carriers that are not always familiar with the boots on the ground North Carolina law. And so you want to be real careful about that. You want to consult with a North Carolina lawyer when you get that in. And remember, the counsel that they appoint to defend you cannot advise you on coverage issues. That's a really complicated relationships beyond the scope of what we're talking about today. But you cannot go to that defense counsel and say, give me advice on the terms of the policy. There are many reasons you don't want to do that anyway, but they can't advise you on that. And they're being paid by the carrier. So just consider that. You need to have your own separate counsel advising you from the background. Assignment of counsel is something that, oh, well, we've touched on these things a little bit. The answer is yes, you need your own lawyer. They work for both you as the insured and the carrier. And they are, they're not allowed to advise you on coverage issues. And Amy, I kind of hijacked your slide there. Sorry for that.
No, you're good. I do want to just add real quick onto what Alan said on the prior slide. Sorry to jump around. As Alan mentioned, denial and reservation of rights are two responses you tend to get from a carrier. RORs, or reservations of rights, do tend to be a little bit more common. But there is a third response that you might get. We see it a little less often, but I think it does illustrate why you need your own counsel advising you. And that is when a carrier will extend a defense under a reservation of rights and then file a lawsuit against the insured for a declaratory judgment action, asking the court to declare the policies, to declare the parties' rights under the policy. And specifically, what they're asking the court to do is to find that they don't have a duty to defend and they don't have a duty to indemnify under the policy. And in those instances, you certainly could not have the attorney who was hired to defend you in the underlying case, who is working for both you and for the insurance carrier, to represent you against the insurance carrier in the what we'd call the coverage litigation, the declaratory judgment action. Again, we do tend to see that a little less, but it does happen, and it tends to happen when the carrier feels pretty confident that there is no coverage, but is sensitive to the risks for denying coverage outright that come under North Carolina law, which can submit it to damages in excess of the policy's limits. So just wanted to add that in there. And then, as Alan mentioned, there are a lot of nuances that go into why it is important to have your own independent counsel and what the role and scope of defense counsel is that we won't really get into today. But there are a couple highlights that are easy to focus on and important for you guys to have some exposure to. And as Alan mentioned, assigned defense counsel is paid by the carrier, but it's a little bit bigger than that. They actually, under North Carolina law, have an attorney-client relationship, not just with you as the insured under the policy, but also with the insurance company. For that claim, they are the attorney for both the insured and the insurer. So, as Alan mentioned, they can't get into a battle between the two when it comes to weighing in on coverage. What does the policy provide for? What does it not provide for? Now, a good insurance defense counsel will be generally aware of what coverage issues may exist, because they need to have a good idea, is this a claim that may need to settle or is it one where they're going to hear at mediation there's not money beyond the cost of defense because there are all these coverage issues. So while I can't advise you of those things, they may have some general awareness of them at the same time. They also cannot, most of the time, bring cross claims on behalf of an insured, because those are considered the equivalent of the insured bringing its own claim, its own litigation or lawsuit within an underlying suit. And insurance carriers are not in the business of paying someone to sue someone else. So, as a rule of thumb, they're not going to pay for you to bring a cross claim. There are exceptions and nuances to that. That's part of the reason why it's so important to have your own lawyer in those instances who can weigh in on and give you advice and guidance on whether those claims need to be pursued, should they fall under the insurance coverage or not. So I think we're ready to go to the next slide, Jen.
So cross claim, I saw a question come in about cross claims. Cross claims and counterclaims are just, yes, it's, do you mean if the HOA wants to sue the person suing them? Yes, that's counterclaim. And a cross claim would be suing another defendant. So if you sued Amy and me for, our roles in the transaction, an example of, that would make Amy and me defendants. And an example of a counterclaim was if I sued you back for your role in it. An example of a cross claim would be if I sued Amy as another defendant for her role in it, saying whatever I'm responsible for was caused by her. That's really what a cross claim is. And you get into that a lot with a lot of these types of cases where you have multiple defendants. For example, maybe the board says, look, it was the lawyer that told us to do this, or it was the management company that told us to do this, or it was this third-party contractor that told us to do this. That's an example of a cross claim that the insurance defense attorney is not going to be able to bring. Amy did make mention of declaratory judgment actions. We bring those on behalf of associations when carriers won't move off their position of denial if we feel like there's a good case there. So there, when you get that denial letter or you get that reservation of rights letter, I mean, a tool in your toolbox, if the policy supports it, is to, if you can't get the carrier to move off their position, is to bring that lawsuit. Often those are in federal court, but you bring those lawsuits in order to kind of advance the ball and resolve that issue. So, Jen, if you'll go back one slide, I just want to touch on a few things with this in our last couple of minutes, then we'll try to take some more questions. And I did see the question that just came through about management companies, and I will return to that in just a second. So a couple of litigation considerations. We talked earlier about eroding coverage limits, the role of insurance defense counsel, all of that sort of thing, reservation of rights. I've seen all too many times you get to mediation and the carrier, that's when you're sitting down in a room trying to work this out with the plaintiff. The carrier is there. They usually send a separate representative that is not the insurance defense counsel. They'll send somebody to actually, write a check. And a lot of times they'll take the position in that case that the insurance defense counsel has given them a trial budget. Their exposure on the duty to defend is, call it $50,000, and that's all they've got to throw in the hat. And what they're saying there is, well, we don't think that we have a coverage obligation. So if you lose, we don't think we owe you any money or we have to pay any money on your behalf. And so we'll throw in what the rest of our defense obligation is as it's been estimated to us by the insurance defense counsel. And that's all you get. And then you got a plaintiff over there that says, well, I want $10 million. So how do you resolve a case like that? You need to take your own lawyer to the mediation because what you end up with is a mediation within a mediation. And you get into arguments with carriers inevitably about whether there's coverage or not. A lot of times in advance of those mediations, we start to take positions with carriers about whether there's coverage or not. And so it's complex, it's a complex animal, but the moral of the story is you need your own lawyer to advocate for your own interests under that contract. Communications, just be careful about that tripartite relationship that Amy mentioned earlier. I mean, your insurance defense counsel is going to have an obligation to that carrier, an attorney-client relationship with that carrier. You're not going to want to forward them anything that deals with your, coverage disputes or advice you're getting on coverage disputes, anything you don't want the insurance carrier to see. And this ties into the question we got, what if your property management company is sued too? Well, it just depends on the situation. Question came in, don't property management companies often have their own insurance? Yes, they do. It's a slightly different nature of insurance that's called errors and omissions insurance. And that is a little bit different than directors and officers coverage. Directors and officers coverage is covering the management company if you buy it and you get them covered as an agent of the association. That's a little bit different than coverage for a mistake or an error or an omission or you forgot to do something. And so you don't want to take the risk as an association that the property management company's insurance is going to kick in and cover it. And here's a few reasons why. One, you don't know what they bought. And you can require that they have certain insurance, but you don't really truly know what that is unless you get the policy and you analyze it. And that's probably beyond the scope of what anybody's realistically going to do. The other thing is you don't know how much of a stomach the property management company has for fighting with the carrier if their carrier says, no, we're not going to provide you any defense. I mean, you're putting a lot of faith in unknowns and things you can't control. And so if you're looking for comprehensive insurance, it makes sense to get the property management company insured as well, just to have another iron in the fire. You just want to up the coverage limits a little bit. Also, and I'm sure many of you have seen this, several property management companies are quite understandably requiring that the associations include them as an insured under the directors and officers policy as a condition of the contract. Jen, you can take it on to the next one. I think that wraps us up.
Great. Yeah, I think it does. I'm going to give everyone just a moment in case they do have questions they'd like to type in at the end. While we're waiting on that, Alan and Amy, do either of you have any opinion on specific insurance companies that you know who are proficient in consulting and creating a policy for HOAs?
Yes, so there are definitely several. So let me just make sure that we're all on the same page. This is not, although you can customize a policy and work with a carrier to get it to adapt to your specific needs, this is not something they're going to have to create out of the ground from whole cloth. These policies are out there in the market. They're available. We're talking about sort of fluffing the edges a little bit rather than building the whole thing from scratch. In terms of carriers, ones that you see quite frequently are in the D&O space: Cincinnati, CNA, Travelers. We've seen some others around the edges, but those are really three kind of core carriers that we run into frequently, and they all provide good coverage. In terms of agencies, if you are interested in who as an insurance, and this may be frankly the better answer to the question, who as an insurance agent understands all of this stuff and who is going to go get you the best coverage that you can afford, call us directly and we'll be happy to pass along some friends and folks in the business that we think highly of. In all candor, we do represent some of them, but there are some really sophisticated agents out there that do a really good job. And your agent is a key relationship when it comes to D&O coverage.
Great. Thank you so much, Alan. I don't see any more questions, so I do think we can wrap up for the day. Amy, thank you so much for working through your audio issues. I'm glad we were able to get them worked out and everyone could hear from you. And thank you, Alan, too, for stepping in on those few slides. For those of you in attendance, following the webinar, we will send out an email with a link of articles related to the discussion today, as well as a recording of the session, a copy of the slide deck, and a link to sign up for future community association alerts. We thank you today for attending and we appreciate your time. We also hope you're able to take some of the information you learned and apply it to your own organization. Thank you again, and that concludes today's seminar.